independence for the exercise of judicial power. However, this must be taken together with the provisions for other safeguards for the promotion and guarantee of the independence of the courts-martial, and then determine the effect of such appointment on the independence and impartiality of the members of the court. The provisions for the appointment of personnel on courts-martial must be in conformity with the provisions for appointments of judicial officers in the civil courts and ensure competent persons sit in all courts. D, term of office, that is security of tenure. This relates to the terms of appointment of the members of the court, including the judge advocate. The appointment of members of the courts martial is by the High Command and for a period of 1 year only, though eligible for reappointment. There are also waiting members who are appointed and can be called upon to sit in court as and when needed to realize quorum. See Regulation 21 and 23 of the UPDF Act Rules of Procedure Regulations. The fact that a member of the court is appointed only for a short period of time and on an ad hoc basis means that such a person may have no cushion against external influence by the one who appoints him or convenes the court. They do not have protections of security of tenure available to civil judges in Article 128 of the Constitution. I therefore reach the conclusion that the provisions of the law governing the courts-martial do not guarantee their independence or impartiality. E, convening authority and prosecuting authority. The convening authority performs an important role in the court-martial judicial process because the laws grants it the dual role of the court and that of the DPP. Under the powers conferred on it by Regulation 21, this authority, among other things, determines the charges to be preferred, appoints the prosecutor, issues a convening order, determines the time of trial, and procures attendance of the witnesses. It has been held in other jurisdictions, in criminal prosecutions, it is an imperative that the convening authority lies with court, which enjoys guarantee of institutional independence from the body prosecuting cases in court. However, with regard to the courts-martial, the situation is wholly different. The military appoints the convener of the court from within its ranks, and similarly does so for the prosecutor of the court. It also appoints officers who are under its command to preside over the court, but accords them no security of tenure in the exercise of their function as members of the court. This situation does not portray or manifest an impartial and independent court. Accordingly then, its constitution and exercise of judicial function is unconstitutional, as it violates Article 28(1) and 44(c) of the Constitution. F, existence of other guarantees against outside pressures, also known as objective impartiality. Most of the determinants of independence and impartiality of courts have been institutional. The other aspect of fair hearing is the legal procedure available to a suspect who appears before the GCM. Procedures of fair trial are to be observed by all courts and tribunals that are an integral part of the judicial system. No adherence to a fair hearing has a double-edged effect. The obvious one is the denial of an accused person the right of due process. The other may have an adverse effect on this, as some accused person may also escape punishment under the guise that they were not given fair hearing. Out of the minimum guarantees for fair hearing under Article 28, I only consider two. I find that the courts-martial do not guarantee the right, adequate time and facilities for the preparation of a defense and to be tried without undue delay. And they also foreclose the right of appeal to ordinary courts. With regard to the right of appeal, there is international consensus that military laws and other legislation should never foreclose the right of appeal from decisions of military courts. A general foreclosure of the right of appeal to ordinary courts, inclusive of convictions for non-capital offenses, is by any legal standard unacceptable and is in our jurisdiction clearly unconstitutional. It has recently been held by the Court of Appeal that the right of appeal to the ordinary courts from military courts is unavailable since the UPDF Act does not provide for it. See Muamuza case. The interpretation that highest appellate court does not refer to the Supreme Court limits the rights of military personnel as compared to civilians in capital cases, in a way that is not justified under Article 43 of the Constitution. Any law where there is no provision for the right of appeal to the Supreme Court for a person who, upon trial and conviction, is liable to suffer the penalty of death is inimical to the right to a fair hearing. Hence, it contravenes Articles 22(1), 21, 28, and 44C of the Constitution. Having regard to what I have discussed above on this issue, in the light of the rights to a fair trial enshrined in our Constitution, I am therefore in full concurrence with the Constitutional Court in this regard, and accordingly, ground 2 of the appeal fails. Ground 3 and the cross appeal. I have already found that the provisions for the military courts do not have the requisite safeguards that would ensure fairness and impartiality in the exercise of their judicial function. I should point out that even if they pass the test for fairness and impartiality, it will still be incumbent on this court to determine whether or not it is constitutional to try civilians in the general court-martial or other military courts or tribunals. The impugned provisions of the UPDF Act provide that only persons subject to military law can be subjected to trial in a court-martial for a service offense. A service offense is defined in Section 2 of the Act thus, open quote, service offense means an offense under this Act or any other Act for the time being in force committed by a person while subject to military law. Persons subject to military law are listed under the impugned Section 1191 G and H, which is now 1171 G and H, of the UPDF Act as follows. G. Every person not otherwise subject to military law who aids or abets the commission of a service offense. H. Every person found in unlawful possession of 1. Arms, ammunition, or equipment, ordinarily being the monopoly of the defense forces, or 2. Other classified stores as prescribed. Both paragraphs G and H of Section 119, now 1171, of the Act are wide enough to encompass civilians within its purview, read together with Sections 2, now 1, and 179, now 177 of the Act. A key ingredient for the sustenance of the charge against a suspect as an accomplice is the naming in the charge sheet of a principal alleged to have committed the offense, which the person charged together with the principal allegedly aided or abetted. This is clearly what the ordinary meaning of the words used in the provision mean. I would accordingly agree with the majority decision of the Constitutional Court that in failing to name in the charge sheet the principal to whom the respondent was allegedly an accomplice, rendered is being charged before the court-martial under the provision of the then Section 1191H of the UPDF Act unlawful for being defective. However, should it be determined that the military court has no jurisdiction to determine matters involving civilians at all, this finding will be of no effect. The purpose and effect test in principle of constitutional interpretation is vital in determining the constitutionality of legislation. The purpose of the military courts provided for under the Constitution and the UPDF Act is to promote and ensure discipline in the military. Courts martial or tribunals are specialized courts meant to serve the function provided for in Article 209 of the Constitution, for which they require the highest form of discipline. The current effect of trial of civilians in the military courts for criminal offenses is that they will not partake in the rights enjoyed by their civilian counterparts who appear in the civilian courts for the same offenses. This includes the right to a fair hearing discussing the resolution of ground 2 under Article 28(1) and as provided for in the international covenants discussed above. Worse still, such persons can face trial for offenses whose trial are within the purview of the ordinary courts, with the military courts having right to impose the death penalty, and yet the law as it stands does not avail the convict the right to appear to the Supreme Court. This limitation on their rights to appear before a civilian court is not justifiable under Article 43 of this Constitution. Militarily limited to cases where the state party to the covenant can demonstrate that recourse to such courts is necessary and justified by objective and serious reasons in concreto. I'll explain what in concreto is. That is, to try civilians in a military court, the state must really demonstrate and prove to the satisfaction of court that it is inevitable, it cannot be done otherwise. So, it must be proved that the ordinary courts are not competent to hear the case, that the civil courts or ordinary courts cannot hear that case. They lack the competence to do so. B, other alternative forms of special or high security civilian courts are inadequate for the task. Hence, recourse to military courts is unavoidable or inevitable. C, referral to military courts guarantees full respect for the rights of the accused and as prescribed by Article 28 of the Constitution. The issues I've been discussing this afternoon. The burden of proving the existence of these exceptional circumstances lies with the state. It is therefore incumbent on the appellant to demonstrate that the trial of civilians by the military courts is connected to the purpose in Article 209 and 210 of the Constitution in a way that is justifiable under Article 43 of the Constitution. From the peculiar facts of the instant case, as is discernible from the record of appeal, it is clear that there was no assessment of the individual circumstances apart from the fact that one of the accused was military personnel at the material time. The provisions for the blanket trial of civilians in the military courts, either as principle in Section 1171H or as accomplices in Section 1171G, does not satisfy the limitation requirements of Article 41 of the Constitution. They are therefore unconstitutional. Likewise, the act of the trial of civilians in the military courts under those provisions is unconstitutional. Excuse me. Ground 3 of the appeal would fail, while the cross appeal succeeds. Grounds 1 and 4, jurisdiction over subject matter. The impugned sections of the UPDF Act under grounds 1 and 4 of the appeal challenge the competence of military courts to try offenses under all enactments. Section 2, now 1, taken together with sections 179, now 177, and 119, 1G, now 177, 1G, of that act leads to the concurrent jurisdiction of the military and civilian courts in criminal matters. The question here for the consideration is the constitutionality of this provision. In the light of Articles 28 and 44 of the Constitution, which the respondent contends requires trial of criminal offenses in ordinary courts before civil judges. Having found that the courts martial should not generally try civilians, I would narrow the issue at hand thus, open quote, should military officers be tried in the courts martial for all civil offenses in addition to disciplinary offenses? Close. Does their trial in the courts martial for civil offenses contravene Articles 28.1 and 44C of the Constitution? Article 28.1 of the Constitution does not expressly bar trial of military personnel in a specialized military court, which meet the criteria discussed in Ground 2. This is because judicial power can properly be given to specialized courts such as the military courts. Does that exception include trial of military personnel for crimes under other enactments? I find the answer to this narrower issue in the determination of the purpose and effect of the impugned provisions. I have already held that the maintenance of discipline is a valid purpose. The effect of the impugned provisions of the Act is that all persons subject to military law will face trial in courts that are markedly different from the ones their civilian counterparts are subjected to for the same offense. In light of the non-derogability of Article 28 of the Constitution and the right to equality under Article 21 of the Constitution, I do not find it justifiable to limit the rights of military personnel as such. I therefore find that the impugned sections 2, 179, 1191A of the UPDF Act adversely affect the liberty interests of all persons subject to military law. Offenses not triable by the courts martial. There are other vital reasons militating against trial of persons subject to military law for all offenses. The court has previously held that there are certain offenses that are not triable by the court martial. This is so where a particular act grants jurisdiction under it only to specific court or only with consent of the DPP. It would therefore be wrong for Parliament to cause a conflict by conferring on courts martial jurisdiction to try such an offense or a similar offense. Where an offense attracts the death penalty, a court martial should have no jurisdiction to try it until a right of appeal is created from sentences for offenses attracting life imprisonment and death penalty to the court's record as is available to the other persons and provided for by the Constitution. The trial of criminal offenses attracting those penalties is unconstitutional for violating Section 28.1, Article 28.1, 44C, 21 and 22 of the Constitution. Effect of subordinate court subject matter. Additionally, as already noted, the General Court Martial and other military courts are all subordinate courts. See Attorney General against Uganda Law Society, Mulenga, Justice of the Supreme Court. However, I do not agree with the finding in the Attorney General Uganda Law Society that the General Court Martial is subordinate but not lower than the High Court. That is self-defeating. It's contradictory. That it is not lower than the High Court, and enabling it to handle offenses at par with superior courts of record. Assigning the ordinary English meaning to the word subordinate, all courts martial are subordinate courts created under 1D can only have jurisdiction that is lower than the High Court. Holding that it is subordinate but not lower than the High Court is contradictory. It actually makes no sense. It is illogical and has the potential to create an absurdity when it comes to the hearing of capital offenses. Should Parliament desire to grant them the jurisdiction to handle capital cases, then it will need to do so in line with the Constitution. With this finding, the hearing by all courts martial of offenses within the jurisdiction of the courts of record is unconstitutional under the Articles 28.1, 44C, 128.1, and 129D. I hereby find that Section 1, 177, 117H, 1H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offenses within the General Court Martial and other military court tribunals. Basing on this analysis and finding, grounds 1 and 4 of the appeal would fail. Upon examining the objective of the law and the authorities cited, I find that the impugned provisions of the UPDF Act are overbroad and rationally connected to the broader purpose. The trend in democratic dispensations, especially in the new democracies such as Uganda, which witnessed gross human rights violations in the past and reminds itself of its ugly past in the preamble to the Constitution, a sober decision has to be consciously made. Sections 2, now 1, 170, now 177, and 119(1)H, now 117H, 1H, that allow the trial of persons subject to military law for all offenses under other enactments without any qualification is overbroad. The need to maintain discipline is no justification for the trial of members of the UPDF who are within the country by the military courts, and yet there is a functional judiciary. Any disciplinary action on an officer can be affected after a finding of guilt by the ordinary court. I hereby find that Sections 2, now 1, 179, now 177, and 119(1)H, now 117(1)H of the UPDF Act are unconstitutional insofar as they, without qualification, allow for trial of persons subject to military law for civil offenses within the General Court Martial and other military courts tribunals. Basing on this analysis, as I've said, grounds 1 and 4 of this appeal would fail. Having made the findings that the provisions of the UPDF Act that confer powers on the military courts to exercise judicial powers are unconstitutional, there arises the consequential issue of the fate of those who, at the time of this decision on unconstitutionality of the UPDF Act, are facing charges or undergoing trial or have been tried and convicted before or by the military courts. This issue was neither raised nor canvassed at the hearing of the appeal. So this court has not had the benefit of counsel's opinion on the matter. Nonetheless, it is a matter of great public interest, hence this court has to deal with it. Issues concerning the extent to which judicial adjudication has retrospective effect, especially regarding a finding that a law or act is inconsistent with the Constitution, is not novel. See Duke Mabeya and A against the governor of Abba Hill Prison, whose citations are given. Two rules have been developed which have gained universal recognition and application. First is that once a law has been declared unconstitutional, then applying the principle of direct review, the declaration has a force of retroactive application. Where, however, the accused person was convicted under a law that is later declared unconstitutional and has either exhausted the appeals or has not pursued an appeal, the matter is taken to have been concluded. In such circumstance, the declaration of unconstitutionality of the law has no retrospective application. In retroactive application of new rules, there is a difference between civil and criminal cases. We are here concerned with the latter. Whether a decision announcing a new rule should be given prospective or retroactive effect should be determined at the time of that decision, as this one here now. Thus, there is a further difference between criminal cases on direct review and those on collateral review. Direct review concerns those criminal cases where the person seeking relief arising from the new rule has not yet been tried, is undergoing trial, has been convicted but is still pursuing a direct appeal, while collateral review refers to those cases where the criminal defendant has exhausted all direct appeals, if any. I cite the authority responsible. In Uganda, the Constitutional Court in Mabea case and American jurisprudence link letter case cited, United States Johnson case, Griffith Kentucky case, Stovall Deno case, and the court cited this and came to the conclusion that retroactivity should depend on, 1, the purpose of the new rule, 2, the extent of reliance on the new rule, and 3, the effect on the administration of justice of the retroactive application of the new rule. The decisions following link letter laid down how this rule would apply to pending cases and those on appeal under direct review. The current American position elucidated in a nonated constitution prepared by Congressional Research Service at the Library of Congress and quoted in A against Governor of Upper Hill Prison, stated as follows, open quote. The court has now drawn a sharp distinction between criminal cases pending on direct review and cases pending on collateral review. For cases on direct review, a new rule for the conduct of criminal prosecution is to be applied retroactively to all cases, state or federal, pending the direct review or not yet final. Thus, for collateral review in federal courts of the state courts, criminal convictions, the general rule is that new rules of constitutional interpretation announced after a defendant's conviction has become final will not be applied. Thus, application for habeas corpus based on a judicial decision subsequent to a conviction becoming final and not otherwise under direct appeal or review fall into the category of collateral review and therefore not entitled to rely on new rules of constitutional interpretation. This principle is apparently not novel to our modern time, as Cicero is credited with having coined the maxim, summum ius summa iniuria, variously translated but classically as the strictest application of law is the greatest injustice. This general principle regarding the effect of declaring a legislation unconstitutional was succinctly stated by Murray J. in A against the Governor of Upper Hill Prison as follows. In a criminal prosecution, where the state relies in good faith on a statute in force at the time, and the accused does not seek to impugn the bringing of or conduct of the prosecution on any other grounds that may be in law, open to him or her, including the constitutionality of the statute before the case reaches finality, on appeal or otherwise, then the final decision in the case must be deemed to be and to remain lawful, notwithstanding any subsequent ruling that the statute or a provision of it is unconstitutional. The learned CJ explained the meaning of a collateral attack as follows. A collateral attack arises where a party, outside the ambit of the original proceeding, seeks to set aside the decision in a case which he has already been finally decided. All legal avenues including appeal, having been exhausted, for reasons that were not raised in the original proceedings, but for reasons arising from a later court decision on the constitutionality of a statute. He made a comparative survey and review of various jurisdictions on the issue and found commonality in the decision taken by them on it. He then said, the question of retrospectivity in the form raised here is one which is material to all legal systems. The fact is that at no stage during the course of the hearing of this case was the court's attention drawn to any system of justice in which a finding that a law is unconstitutional, even where this is deemed to be so ab initio, meant that previous and final judicial decision based on such a law must inevitably be considered unlawful and of no effect in law. I'm not aware of any legal system to that effect. Referring to the situation obtaining in the U.S., said there are transcendent considerations which militate against complete or absolute retrospectivity. Fundamental interest of public policy requires limitation on the retroactive effect of judicial decisions. The legal order and the administration of justice is not one perfect symmetry. As Justice Benjamin Cardozo observed at page 161 in his seminal work, The Nature of the Judicial Process, Yale University Press, 1921, we like to picture to ourselves the field of the law as accurately mapped and plotted. We draw our little lines and they're hardly down before we blur them. Although judicial adjudication do not have retroactive effect, there are important exceptions and restrictions to that effect. A line must be drawn in the interest of justice. The CJ further elucidated on the matter thus. A judgment condemning a statute for being inconsistent with or contrary to the Constitution does not mean that all which was done or decided under the statute prior to the decision on constitutionality is in all circumstances void and of no effect. It is a principle which is, for reasons indicated in the various judicial dicta which I've cited, consistent with the Constitution as a whole. The common law dimensions of our legal system and the legal system of many other countries in which the courts have the same or an analogous power of judicial review of the validity of laws. Then he said, certainly issues concerning the constitutionality of statutes are on a plane higher than the mere common law. They concern questions fundamental to the rule of law, the protection of rights, and the very framework within which, in the words of the preamble of the Constitution, true social order is attained. Normally, those fundamental constitutional concepts, such as the rule of law, individual rights, justice, and a social order based on that rule of law blend together so that the principles of constitutional justice to be applied to resolve issues may be readily deduced. On other occasions, some of those considerations may be competing or even conflicting ones, where the courts have to balance those different interests so as to do justice within the framework of the Constitution. In this instance, one may say in broad terms that there is a competing interest between the claim by the applicant that he stands convicted under law which has subsequently been found to be inconsistent with the Constitution as from 1937, and the interest of justice, including the rights of the victim, where he was otherwise lawfully convicted of unlawful carnal knowledge of a 15-year-old girl, in circumstances where, as his counsel acknowledges, the conviction and sentence were not tainted by any want of fairness or injustice. Thus, the effect of absolute retroactivity, for which the applicant argues, in a sense raises competing consideration, which the court has to address having regard to the provisions generally of the Constitution and what Henchy J. alluded to as transcendent constitutional consideration, the public interest, the common good, and social order. In response to the argument that the declaration that a law is unconstitutional, the learned CJ had this to say: absolute retroactivity based solely on the notion of an act being void ab initio, so as to render any previous final judicial decision null, would lead the Constitution to have dysfunctional effects in the administration of justice. In the area of civil law, it would cause injustice to those who had accepted and acted upon the finality of judicial decision. Rights which had become vested in third parties as a consequence of such decisions would be put in jeopardy. The application of a principle of absolute retroactivity consequent upon a declaration of unconstitutionality of an act in the field of criminal law would render null and of no effect final verdicts or decisions affected by an act which at the time had been presumed or acknowledged to be constitutional and otherwise had been fairly tried. Such unqualified retroactivity would be a denial of justice to the victims of crime and offend against fundamental and just interests of society. I find these authorities quite persuasive and applicable to the current situation, because the constitutional rules declared touch on the fundamental aspects of a criminal trial in a democratic dispensation. In the present case, we have those who have been charged, those undergoing trial, those convicted and in the process of challenging such conviction, as was the case in the Lieutenant Guang case supra, and those whose conviction is final. This is the situation obtaining with regards to those who have been defendants in the courts martial. I consider that the first three categories that fall under direct review can without any difficulty take benefit from the rules expounded herein as regards trial in the courts martial. However, for those whose trial is completed or who are also referred to as those on collateral review, it is my considered opinion that they fall within the exception enunciated above. In the event, I will make the following declarations. 1. The Summary Trial Authority, STA, and the Unit Disciplinary Committee, UDC, are respectfully, lawfully established under sections 191 and 192, now 189 and 190, and section 195, now 193, of the UPDF Act as military tribunals. 2. The provision of section 197, now 195, of the UPDF Act establishing the General Court Martial as a competent court is constitutional. 3. The General Court Martial created under section 197, now 195 of the UPDF Act is a subordinate court of law but with specialized jurisdiction. 4. The provisions of section 179, 1 and 2, now 177, 1 and 2 of the UPDF Act, read together with section 197, 2, now 195, 2, which grant the subordinate military court's jurisdiction over capital offenses, contravene Article 129, 1D and Article 126, 1 of the Constitution, hence they are unconstitutional. 5. The provisions of section 191, 3, which is now section 189, 3A, and section 195, 3 and 4, now 193, 3 and 4, read together with section 179, now 177 of the UPDF Act, which grants this STA and the UDC the exercise of judicial power of detention and imprisonment of any person tried by them, contravene Articles 23, 126, 1, and 129, 1D of the Constitution. Hence, they are unconstitutional. 6. The provisions of the UPDF Act constituting and providing for the trial procedure of the General Court Martial, the Division Court Martial, and the Court Martial Appeal Court do not contain do not contain any or sufficient constitutional guarantees and safeguards for them to exercise their judicial functions with independence and impartiality, which is a prerequisite for fair hearing provided for under Articles 21, 28.1, 44C, and 128.1 of the Constitution. The provisions of Section 1191G, now 1171G of the UPDF Act, under which the respondent, a civilian, was charged and arraigned in the General Court Martial, contravenes Article 28.1, 44C, and 21 of the Constitution. Hence, it is unconstitutional. The provision of Section 1191G, now 1171G, is unconstitutional to the extent that it permits trial in the courts martial of civilians who have allegedly aided and abetted the commission of a crime, of a service offense rather, or ordinary criminal offense in which a person subject to military law is a principal offender. 9. Sections 2, 179, 119, 1H and G, now respectively sections 1, 177, 117, 1H and G of the UPDF Act are unconstitutional since they confer blanket jurisdiction on courts martial to try civilians. The jurisdiction conferred by Section 2, 179, and 191 1H, now sections 177, 117, 1H of the UPDF Act on the General Court Martial to try persons subject to military law for civil and non-disciplinary offenses committed in Uganda is unconstitutional, as they contravene Articles 209 and 210 of the Constitution. I would accordingly propose the following orders. The declaration of the Constitutional Court that Section 1191G, now 1171G of the UPDF Act, which provides that any person not otherwise subject to military law who aids or abets a person subject to military law in the commission of a service offense is constitutional, is hereby set aside. All charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred. Order. I'm going to chase you out. This is not cloud 9 where you can... So I said all charges or ongoing criminal trials or pending trials before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with competent jurisdiction. 3, this judgment, you just nod, don't stop this clapping thing. Shall have no retrospective effect on any conviction made and sentences imposed prior to the date of this judgment, save where the conviction and sentence is being challenged in a court of law. All pending trials or partly heard criminal cases that fall under the civil law court's jurisdiction, which are against members of the UPDF who are subject to service law, must be transferred to the civil courts with competent jurisdiction. 5, save for the issue of the establishment of the General Court Martial as a court of law, this appeal fails and is hereby dismissed. The cross appeal is hereby allowed. The respondent is entitled to the cost of this appeal and in the Constitutional Court. I'm going to empty the court and I read the judgment without any of you. Just try me again one more time and you'll see. This court is giving an advisory order to the executive and parliament. An advisory order is an advice which is slightly stronger than an ordinary advice. That's why it is called an order. It does not bind, but it will be foolhardiness if you do not pay attention to. That's really what it is. You may not take it, but at least you give it consideration. That's why in law it is called an advisory order. At times it is called an opinion, but it is an order, non-justiciable, but it is nonetheless an order. Court-martial are not unconstitutional merely by their very nature of being military courts. The people of Uganda pronounced themselves in the course of the making of the 1995 Constitution, expressing their fervent desire to make a break from the ugly past that characterized life in our country, especially the grave abuse of human rights by the military. The Ugandan military has since been transformed into a professional force, and it has made remarkable contribution to ensuring regional peace, security, and stability. It is rather contradictory and rather disconcerting for a military force built on new and commendable professional dispensation to operate under the same legal framework that failed to check or avert military abuse of power with unspeakable ramifications. The 1995 Constitution provided the new wine, which the UPDF Act, as instead through the impugned provisions of the Act, sought to store in old wineskins, as it were. This is a blatant negation of the aspirations, desire, hope, and wishes of the people of Uganda, which the framers of the 1995 Constitution meticulously enshrined in no uncertain terms in the Constitution. It is noteworthy that in Uganda Law Society against and Karugaba against the Attorney General, the Constitutional Court observed that the Constitution was unfortunately being ignored and recommended that Parliament could amend the Constitution to provide for any special needs of the military. It said, open quote, "The UPDF is currently being operated under laws and practices which still contain colonial relics in total disregard of the Ugandan Constitution. No attention was paid to this problem when drafting the 1995 Constitution. This court has no powers to bend the Constitution in order to accommodate special needs, whether legitimate or not, of the army. It is only Parliament that has the power to amend the laws, including the Constitution, to accommodate such special concerns of the army. So far, it has not done so. I must therefore stick to only such interpretation of the law that is consistent with the Constitution as it stands now," close quotes. The current military courts operate in violation of the constitutionally enshrined and securely protected rights to a fair hearing that are equally recognized universally in conventions and other instruments. Thus, there is need for a robust legislative intervention to ensure the UPDF Act is in accord with the cherished aspirations of the people of Uganda, as was unmistakably captured in the Doke Commission report. In the full judgment, I actually reproduced so much of that report extensively. It is therefore incumbent on the executive to generate the policy and Parliament to pass the legislation which addresses and cures the injustice occasioned by the unconstitutional provisions of the UPDF Act, which have now been quashed by providing for military courts that are clothed with the constitutional safeguards of independence and impartiality that are accorded the ordinary courts. In recognition of the special nature of the military, legislation must be put in place that establishes and confers on the courts martial and tribunals the powers to execute lawful jurisdiction over members of the military, and thus fulfill the function of the UPDF. However, this special exercise of jurisdiction must not infringe on the soldier's right to a fair hearing. The state needs to act in order to ensure that the character of military courts and tribunals meet the democratic standards and aspirations of the people, which are clearly enshrined in the Constitution. It is noteworthy that the court advised in 2009 Uganda Law Society against Karugaba that the military courts to be truly independent and impartial, there are desirable changes that the executive needs to address. It noted as follows. In order for this to be applicable to the military courts, the article would have to be modified in such a way as to give the courts independence and impartiality without compromising their military nature. The army would have a parallel judiciary with legally trained soldiers to professionally man the courts. In order to be impartial, the court must have security of tenure and other privileges enjoyed by the other judicial officers in the Ugandan judiciary. It should be noted that the definition of judicial officer contained in Article 151 does not exclude persons exercising judicial power in military courts, close quote. I consider the need for this recommended transformation as relevant today as it was then. In the premises, I would make the following recommendations for consideration by the Executive and Parliament as viable alternatives for the establishment and or creation of military courts in Uganda. These are recommendations. They can pick any, they can reject all, but these are recommendations which the people of Uganda hope they will look into. A, administratively establish the General Court Martial as a division of the High Court without the need to create a new court, with jurisdiction to handle capital criminal cases involving both military officers and any civilians who would exceptionally fall within its ambit, with magistrates within the division handling offenses falling under their jurisdiction. B, limit the functions of the unit disciplinary committees and summary trial authorities to handling strictly disciplinary offenses with no power of imposing sentences or imprisonment. C, utilize the existing magistracy to handle the rest of the criminal cases other than disciplinary offenses committed in Uganda, which are currently falling within the docket of the UDCs. The subordinate military courts can handle criminal cases at the level of Chief Magistrate's Court for offenses attracting life imprisonment and below. Or D, with the advice of the Judicial Service Commission, appoint civilians with the requisite professional legal qualifications to serve as judicial officers in the current subordinate military courts. They would exercise jurisdiction over offenses triable by the subordinate courts. They should have the same privileges and safeguards as their counterparts in the civil courts. Or E, amend the Constitution to establish superior courts within the military court system under Article 129 and clothe them with the requisite jurisdiction and guarantee of independence and impartiality to strike specific military offenses of a capital nature and all other capital offenses under existing laws committed by military personnel. Or F, provide in the UPDF Act for the High Court to sit as a court-martial with power to try all criminal capital offenses within the High Court jurisdiction, and those unique to the military that attract a maximum of life and death sentences. Grant the Chief Justice powers to assign judges to the military courts. A select number of military personnel can act as assessors. Appeals to the court-martial appeal courts would follow the same format, with the Court of Appeal sitting as such. Magistrates' Court would assume the jurisdiction over all other offenses of a subordinate court. G, make provision in the UPDF Act for trial of civilians in military courts to be only under limited circumstances and only after the state has concretely demonstrated to the court by verifiable facts and by objective and serious reasons the need and justification for recourse to the military court. This must not only apply where in relation to specific class or category of persons and offenses. Ordinary courts are not in position to undertake such trial. H. Make provision in the UPDF Act for appeal from military courts and tribunals corresponding to appeals in each of the options suggested above. The jurisdiction of UDCS and SDS must be limited to that of tribunals, handling strictly disciplinary offenses with no power of detention or imprisonment, as is the case with other disciplined forces, such as the police and prisons. Dated Kampala this 31st day of January 2025, Alphonse C. Owindolo, Chief Justice. Now, since my brothers and sisters agree either unanimously or by majority concurrence of the orders proposed in this judgment of the Chief Justice, orders are hereby accordingly given in the terms proposed by the Honorable Chief Justice according to that ratio. Judgment is delivered in Kampala this 31st day of January 2025. And as I said, we intend to avail you the soft copies of the judgment by close of business today.
Of the Supreme Court, on behalf of the respondent, we thank this court for this bold decision, and at the same time, as a senior lawyer, we also seek for forgiveness for some lawyers practice and utter issues they do not understand, which tend to undermine the essence of this court. My Lord, we are sorry on behalf of Uganda Law Society, but otherwise we are so grateful for the bold step this court has taken, and I think we have no way of expressing it. Thank you, my Lord. Much obliged.
My Lord, for my clients who expected to go to the General Court Martial.
Who are your clients?
Councillor
Alaka
and the Lord Mayor, who was sentenced to 1,000 shillings in the General Court Martial. They will miss out on claiming.
The Lord Mayor. That's why he's not dressed as a lawyer today. he thinks I was going to jail him or what?
We're only grateful, my Lord.
You know, this is now we are done. One time he invaded me here. Lord Mayor, when you invaded me with journalists and some stranger lady, I had gone to the Kitezi site to see how an irresponsible administration of a city can cause such misfortune. That's why you did not find me here. I'd gone to Kitezi. Yes. So it's okay. We can go. Yeah.